Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Join in, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the February 14th, 2023 sitting of this panel of the Appeals Court. Happy Valentine's Day, everyone. My name is Vicki Henry. I'm your panel chief today. I'm pleased to be joined by my colleague Suk-Young Shin on my right, and on my left we have Christopher Hodgens. We have 3 cases on today, and in this court, we have argument for 15 minutes per side, and for better or for worse, we do not have rebuttal. So whatever points you want to make in your presentation. And with that, we'll call the first case, 2022 P716, JOAN ARRUDA versus City of Cambridge and others.
Good morning. My name is Robert Feinberg on behalf of the appellant plaintiff, JOAN ARRUDA, and I am joined by my co-counsel, attorney Colleen Santora. Thank you. The issue here is whether a 1/2 inch elevation on a public way can give rise to an actionable tort. It was left in that condition by a private contractor. The issue raised is whether that is too de minimis or trivial to give rise to a tortious action. The appellee, if I may say, concedes in this case that the defendant contracted with the city to perform road work and was in control of the roadway in question and owed a duty to act with reasonable care. That's in page 11 of the appellee's brief. In that sentence, there is no reference to Chapter 84, the defect in the way statute. Rather, there's reference, it seems, to common law tort principles. Newport, as a private contractor, it is the position of the appellant, is not afforded the protection of Chapter 84, and therefore, precedent citing that statute that, as your honors or justices are aware, has been on the books since the 1800s, is really inappropriate. 84 begins with, if such injury or damage might have been prevented or such defect or wanton repair might have been remedied by reasonable care and diligence on the part of the county, city, town, or person by law obliged to repair the same. That is not the defendant entity in the underlying case. The courts have said, and I'll cite the case that I see as very seminal and influential in this area, Doherty v. Belmont, 1985, from the Supreme Judicial Court. The court has said that the purpose here is to limit the liability of cities and towns. These policy considerations do not apply to a private contractor. And the policy considerations which are explicitly mentioned in Doherty v. Belmont are weather patterns and traffic patterns. Those two issues and considerations do not apply here.
Counsel, I had one just factual question. You know, sometimes when there's repaving projects happening, you can tell the pavement has been stripped off. It's often grooved. In this, would someone, what's the state of the record if someone were just looking at this? Could you tell this wasn't the final coat of pavement, or did this look like it might be?
In good faith, Justice, I don't think you could tell that it was in its, I think you would believe it's in its final form. You would not get a sense that the roadway is under construction. There was nothing there to indicate that it was under construction. There was no cones or signage elsewhere at other areas where the contractor was working. There was an indication. Here in the record appendix, and I regret that it's not a very good picture, but it is referenced in the affidavit of Ms. ARRUDA, which is in the record appendix, page 180, upper right-hand corner of that picture. That is how that particular area over which she fell looked. And I do want to get into the picture that is included in the appellee's brief, because that was not quite simply ever asked of the client, was it a fair and accurate depiction of the elevation? Rather, that she was asked, is that how the roadway looked? And this is, of course, all in the record. She said yes, and then she was asked to mark an X the area where she fell. Regrettably, it is our contention that that picture taken from above does not give justice, if you will, to the state of the elevation. One can't get it, nor was the client, as I say, ever asked, was that a fair and accurate depiction of the elevation?
Well, it's not disputed that she's crossing from the street across the crosswalk. In other words, she's not in the crosswalk, she's in the roadway and passing over the crosswalk. Is that right?
That is correct. She is about to enter the crosswalk, and she falls on that granite curb that borders the crosswalk from the asphalt.
And do you think that makes any difference in this case at all?
Well, Your Honor, I have to say that it is commonly anticipated that pedestrians, especially in busy urban areas, are going to not necessarily confine themselves to the crosswalk. More important than what I say is what the appeals court has said in Weiss v. Cambridge, and that is it's up to a jury, which is, of course, our position. It's up to a jury to decide the relative degrees of fault of drivers and pedestrians as to whether they follow the regulatory schemes. I don't think, if I may say, that it's common sense for it to be expected that all pedestrians cross in a linear fashion, going only over the crosswalk.
So if there was unevenness in the middle of the road, nowhere near a crosswalk, you're saying that also goes to the jury? I mean, there's no factual circumstance in which it can be decided as a matter of law?
Well, if the unevenness is caused in the roadway by a private contractor, I would say, Justice, that yes, that would be actionable. And the reason I would is this notion of de minimis as defined by the courts in interpreting Chapter 84 just doesn't apply to a private contractor. But I do want to say that someone who is approaching the crosswalk, it would seem to me it would be one of the factors that a jury could consider. It's not that they're
Right, I'm just trying to pinpoint the limits of what you're arguing. So, I mean, reasonableness can be decided as a matter of law, right?
There are circumstances.
So if there's unevenness, let's say in the middle of an interstate, and a pedestrian decides to walk out in the middle of the interstate, that would you agree that could be decided as a matter of law?
Yes, yes.
Okay. But, so here, if it's a local street, but it's just nowhere near any sort of pedestrian crosswalk, there's a half-inch unevenness in the road, you're saying that that has to go to the jury?
I believe, Your Honor, when that is left in the condition, along with some other factors, if the court is willing to hear, along with other factors, I think that is appropriate for a jury. Those other factors are things like putting cones, which this defendant has done in nearby intersections, signage to demarcate, as the court has said in Spring v. Foodmaster, also cited in my brief. And we have an expert's affidavit in the record appendix, page 177, and he mentions the importance for certain things such as painting to demarcate by color, and cones or other signage. So there would be circumstances that I feel if you put the whole cluster of circumstances together, certainly in this case, and she is approaching the crosswalk, certainly in this case, one could say that it's a matter for a jury if that were 14 feet further back from the crosswalk. But I think this is a stronger case, given that it is just about to be on the crosswalk, and we know people do not necessarily confine themselves to it, but as I see it, that is a factual issue.
On the issue of the warning, am I reading the record correctly that Mr. Howard testified that typically a raised lip like this would be painted if it's in a pedestrian line of travel, and that in fact he believes this probably was painted and wore out? Am I reading that correctly?
The first half, you are reading it correctly, that he does believe that these would be painted if they are in a pedestrian path of travel, and that comes up in my brief. He made the unilateral decision that this is not a pedestrian path of travel, and I think that was a decision that a jury should hear as to the reasonableness of that decision. It was his statement, again, pedestrian path of travel, no, we do, if it's not, we don't have to take care of it. In terms of this particular area having been painted, he did say it, but I think, frankly, and perhaps that would help my case, I don't think that was accurate. I think he must have misspoken, because there's no evidence here that that particular elevation was painted prior to Ms. ARRUDA's fall. In fact, they had just finished working maybe the week before and were intending to come back. But I do not contend that there was painting there, though.
Okay, so you don't read that as his acknowledgement that it should have been painted?
No, I do not. But I do think it's very relevant for a jury to hear that in other circumstances or other intersections or roadways, they have painted them. It's just that he felt this was unnecessary, as I say, because it was not a pedestrian path of travel.
But what we do have here is we have two different kinds of stone, right? Because there's this border on the crosswalk, and we do have the painting of the crosswalk.
Well, it is granite. It is not a yellow kind of painting that is in the papers that they did subsequently, for example, in a nearby street or intersection. And yes. There is a slight difference in color, one might say, because of the granite versus the asphalt, but it is not as bright to indicate to a passerby that there is this half-inch elevation. If I may say, they intended, as he says in his deposition, this Mr. Howard, that they would come back in the spring of 2018, 6 months later, and they would then put the final coat on. So they knew when they left that week, they knew that it was not in its final form. And I think a jury should be entitled to hear what is the burden of putting the painting on that lip, as he calls it, or elevation, and hear the other factors as to why, since it was not in its permanent state, certain measures should be taken in a certainly a heavily urban area, heavily trafficked by pedestrians and cars, that certain measures would have been reasonable and appropriate to have taken, which they didn't. But they were mindful of the fact that this was not in a final condition. We never, by the way, contended, as is perhaps suggested in my brother's brief, we never contended that he said this particular area should have been painted. In fact, he says it shouldn't have, because he said it was not a pedestrian path of travel. We were merely pointing the fact out that he said these things should be painted to show that in other areas where it's deemed appropriate, this defendant has, in fact, undertaken to do that.
So what precisely, then, is the breach of duty you're alleging here?
That there was a failure to either come back, which this Mr. Howard says, the next day, to mill it so that it would be flush with there would not be an elevation, rather it would be flush, or in the absence of that, to put some sort of signage and cones, as our expert has put in an affidavit, to alert pedestrians. Certainly, this is an abrupt change in the elevation. She's holding her 6-year-old granddaughter, and serious injuries can happen. One thing I want to mention, there are no appellate cases to our investigation that are right on point here. There's the Jennings v. Tompkins case, which was a private defendant, and the rise there was 3/16 of an inch. In Douglas v. Shepard, several years later, in 1914, that was actually only 1/4 of an inch, or 4/16. There is a misstatement, if I may, in the appellee's brief, because the appellee says it was a 4-inch rise. It was not. That rise of 4/16 or 1/4 went on for 4 inches. So it was a different nature. And other cases.
So, I mean, I guess it's really hard to draw fine lines between measurements, a 1/4 inch, a 1/2 inch. So in the Damon versus SSB Realty case, which I know is a 128, but it involved a private defendant, and we said, or a panel of this court said it wasn't enough to go to the jury. So what's the distinction there? I mean, are we just talking about 1/8 of an inch versus half an inch?
Exactly. Well, I guess.
Or is that case wrongly decided in your view?
So that was a 1/8 of an inch. I would
Right.
concede that there are certain things, as Doherty v. Belmont, there are certain circumstances which are, even at common law, cannot give rise.
How do we draw that line? Is it just a question of measurements?
If I may say, I think it's instructive what the SJC did in 40 years ago in Doherty v. Belmont. They dealt with a 1/2 to 3/4 of an inch, and that would have been an opportunity to say this could be a 1/2 inch that cannot give rise. It is too de minimis. It is too trivial or insignificant. They didn't. In fact, they went on to discuss and consider common law tort principles. That, it seems to me, would have been the time for them to have made the clarion call that no, a 1/2 an inch just doesn't.
So is Damon rightly or wrongly decided? I mean, there we're talking about a sidewalk where pedestrians are expected to be, and even then we said it wasn't enough to send to the jury.
Right. But that was grout, and I think inevitably you see that. And again, it was I would say it was very trivial. I don't think it was wrongly decided. I think 1/8 of an inch, as opposed to an abrupt change here of 1 inch, sorry, 1/2 of an inch, is a markedly different scenario. And again, with my final few seconds here, why wouldn't the Doherty court have said, we're setting a bright line here? And 1/2 of an inch just in the record is not enough. Thank you very much.
Attorney Kennedy, when you're ready.
Thank you, Your Honor. May it please the Court, Steve Kennedy for the appellee Newport Construction. I'll start out with one of the main arguments in the appellant's brief is that the Superior Court judge did not consider other factors when making the decision that this 1/2 elevation was insignificant and did not give rise to an actual claim of negligence. Respectfully, I think that's a bit misleading. There were relevant factors considered by the judge in his decision. Some of those factors are undisputed, contained in the statement of facts, and others are, I would submit, immaterial and irrelevant. So the fact that the defendant created the condition, not in dispute. The fact, in the light most favorable to the plaintiff, that this difference in elevation is a 1/2 an inch, okay, that's fine. But the other factors that are discussed here are they could have filled in the binding and grading the next day. The defendant didn't utilize warnings or signs. They intended to remedy in the future this issue. So those were found by the judge not to be material or relevant because the underlying condition renders the defendant has no obligation and no legal duty with respect to something so de minimis, a 1/2 an inch elevation.
Yes, but why shouldn't a jury have the chance to make that decision?
Well, because at some point there has to be a threshold of common sense when cases are brought forth alleging defects. Some defects just cannot be actionable here.
But you would agree, though, that those cases, when we're talking about, 1/4 inch, 1/2 inch, and so forth,
right.
Those are cases that involve wear and tear, naturally occurring type situations. None of those cases involve a contractor who has actually created the condition, was aware of the condition, and allowed it to remain. Would you agree with
I
that?
don't think there's any evidence this contractor was aware of this particular condition, quote unquote, and I don't believe that there's any standards.
Well, he wasn't aware of the exact measurement.
Right.
But I believe Mr. Howard did testify he was aware that it was not flush, right?
Right. Correct, Your Honor. I understand that completely. But again, with no industry standards or regulations in place that would say you cannot leave a 1/2 an inch elevation in a crosswalk binding, that's just not proper. There's no evidence to that, Judge. And these other cases, there are plenty of other cases there. I believe we cited 10 at least that discussed defects that just aren't that
You
don't meet
need
that threshold.
evidence of an industry standard in order to establish a duty of care.
No, I think it would be certainly an argument it's evidence of negligence, and that would go to a jury.
But you don't
here
need
we
it,
don't
right?
have
I
that.
mean, sometimes a duty of care can be decided by common sense, right?
Well, that's the case law that is cited here, Sarkisian, and I believe the other case that begins with a P, Your Honor, I can't remember right now. But certainly common sense does dictate that. And I think to look the other way is to suggest that it's not a duty of reasonable care, it's a duty of absolute perfection, that the street should be completely smooth, there should be no change in elevation. And that's just, quite frankly, unreasonable.
Let's say there was an unevenness in the crosswalk, within the crosswalk itself, that was created by a contractor. I know that this crosswalk was pre-existing, but let's just assume it was created. Would that go to the jury?
I think that does make a bit of a difference, Your Honor, and I believe that's what the distinction was in the Doherty case, was I think that defect, quote unquote, was a little bit different here, surrounded by concrete and I believe in the direct path of pedestrian traffic.
So the distinction here is that she was approaching the crosswalk as opposed to walking within the crosswalk.
I think that's a fair distinction, Your Honor. I mean, here's the photograph shows the X here, and I don't believe there's another issue that's not in dispute, that she was coming sort of cross this way, and not actually in the crosswalk itself. Now, if there was some sort of defect in the crosswalk area where your pedestrians are expected to come and go, then that might be a different case.
Isn't it reasonable to assume that people will not necessarily cross exactly where they're supposed to cross? I mean, it happens all the time, right?
Sorry, Your Honor, I think it is right. Right, correct. But again, we're dealing with something that's so de minimis and so minute that would a reasonable person be expected to be aware of that and remedy it? I think that's the key here. So again, the plaintiff was walking in the street, passing adjacent to a crosswalk, using it to cross the street. There's a small change in grade. It was visible. The border protruded a half an inch. Again, undisputed, but the judge says that there is no obligation or legal duty under the facts of this case when you have elevation change that is absolutely de minimis, a half an inch. And again, it's a test of reasonableness. There are plenty of cases. And I think one of the cases cited in the appellant's brief to suggest that a half an inch was found to be a defect, an actionable defect, was Loudon. But in that case, again, that takes into account other factors. There was a half an inch protrusion, but there was also a loose brass nose on the stairway. So those two that's a combination that would, in fact, probably give rise to a defect. Here you have a static change.
When we're talking about de minimis, though, the cases that, as I've looked at in the briefs, it seems that that concept of de minimis arises, as in that Watertown case, the Valenti versus Watertown. It arises in a municipal context where the Supreme Judicial Court has said to hold a municipality liable for a de minimis defect would put an undue burden on municipalities. I mean, the court came right out and said that it's an undue burden on municipalities. But here we have a contractor. It's not a municipality. And it's not a defect, it's a result of, wear and tear or frost heaves or anything like that. It's a result of a condition created by the contractor. Doesn't that make a difference?
I don't think it does, Your Honor. I think it is, and again, we're saying it's a defect. I mean, it is an existing condition of construction, I guess, but I understand for the purposes of the argument, I understand what you're saying, Judge, but I don't think that would hold contractors to an unreasonable standard as well. I don't think there should be that much of a distinction. I mean, there isn't perfection. There can't be a standard of perfection when you're dealing with grading and, stripping roadways and repaving.
Do you have a case that says that? Because that language you're referring to, perfection is not required even in sidewalks. That's in the Valenti versus Watertown case referring to municipal liability. Do you have a case that has that language in reference to contractors?
I don't, Your Honor, but I think it's just a case that references in common law in a variety of those circumstances that is the test of reasonableness. And I understand the distinction between a municipality and the private contractor, but here I believe, it's the same argument that a contractor cannot be held to. It's just unreasonable to, you talk about the floodgates opening for lawsuits. If you have a half-inch elevation that is a defect, then there's no end to what can happen, right? And I understand it's an imperfect world, and standards change over time, but there are plenty of examples in the cases that the court does say, it does restrict actions, saying that this is not, the underlying analysis, is this a defect that's actionable, is no, and then that's why. And so, again, the factors applied here by the judge in the lower court decision.
How do we decide that as a matter of law? We say just as a matter of law, a half inch is too trivial to be actionable, but 3/4, would that do it? Would that go to the jury? I mean, how do we draw that line?
Well, I think considering, not in a vacuum, but in context, or considering other factors here. Like, where is it? How did this occur? Where was it? As you mentioned earlier, Your Honor, was it in the direct path expected of people going in and out, or was it on the side? I mean, those are factors that have to be taken into account. But when you do take them into account, the undisputed facts in this case, again, it goes back to the common sense analysis that there is no legal duty of care that can be applied to the facts of this case, given a 1/2 inch change in elevation. And that is a decision that's been made by the appellate court before on a variety of different cases with different fact patterns.
So in terms of the status of the record, is there anything to indicate this binder pavement was not a final coat of pavement to a layperson, not to your client?
Right, Judge. So thank you. I would submit no. I mean, I think we can all see when we drive on the roadway, we call it reclaiming paving, the strip road with a visible curbing or distance in elevation that looks like, well, that should be paved eventually, manhole covers exposed, et cetera. Here, again, dealing with the photograph that's in black and white, that it doesn't, to be fair, suggest that that is obvious when you look at it. It looks like it's a crosswalk, it's painted, and there's a border next to it. So I don't think it has the same appearance as you're suggesting, Judge, in that scenario. So,
So he relies heavily on Doherty, and I guess, I mean, that doesn't look like it was a summary judgment case. That looks like it was a case that happened to go to the jury.
well, I think Doherty is instructive because I think it crystallizes what the analysis is. I mean, it does say certain alleged defects may be so trivial that they cannot possibly constitute negligence, and that's, again, what we're focusing on here. And again, back to common law. Doherty says, at common law, the necessary inquiry is whether the alleged defect is so minor or insubstantial that a reasonable person would not have anticipated injury and guarded against it. That's Doherty, and that language does control here. Would a reasonable contractor be expected to anticipate that there would be injury as a result of this 1/2 inch change in elevation? And the reasonable answer to that is no. And that, again, is the guiding principle in the judge's decision here, and I think that directly applies.
Now, does this play a factor at all? The plaintiff here testified that she noticed the curbing along the street where all this construction was extraordinarily high, suggesting that the road surface was not at its proper height. Does that play any factor in any of this as far as a reasonable person goes? If she was aware, if she had some awareness that the elevation of the curbing, at least on the side of the road, was extraordinarily high.
And you're not talking about the actual crosswalk, Judge. You're talking about on the side of the road?
Well,
Right.
she's talking about the curbing on the side of the road.
I understand. Thank
That
you.
she recognized that it was extraordinarily high from living in the neighborhood, walking on the street due to all the construction, which is consistent with the final course of asphalt not being put down, so the elevation of the sidewalk is going to be artificially high. So she's aware of that, and presumably walking cautiously when she's stepping up on the sidewalk. But of course, we're faced with a different situation because now she's in a crosswalk or going into a crosswalk and encounters an embedded block of granite, which, I mean, that's not typically in the middle of a street, right?
Right, Judge, but I would suggest that is irrelevant, that she makes an observation about a curbing on the side that happens to have high elevation that maybe needs to be, it was reclaimed and needs to be paved over. I don't think that's fair evidence in this case, because we're talking about this confined, the area is confined to the crosswalk and the binding adjacent to the crosswalk. So the fact that she noticed that in other areas, I mean, again, it's not disputed that this is a half-inch elevation. She was aware she saw the curbing, and that's the measurement that, in the light most favorable to the plaintiff, is a half an inch.
In other words, what I'm suggesting is, doesn't that, her testimony, recognizing the other curbing to be extraordinarily high due to the construction in the area, doesn't that kind of suggest that we're dealing with a plaintiff here who's not heedless of the circumstances around her, that she's got a pretty good awareness of some of the hazards that might be afoot, but this particular hazard escaped her notice, being in the middle of the road where the crosswalk is?
I think they're distinctive because it's not the same type of hazard, Judge. Again, with say it's 4 inches on the curbing and here is a half inch, it's just not the same thing. Also, if this were to go to a jury or to go to trial, that notice or the defendant is aware of the conditions does not help her argument necessarily. But I do understand the distinction, Judge. But I think, again, the relevant evidence at trial would be this crosswalk area. What is it? What are we dealing with here with this binding adjacent to the crosswalk? Is it a 3 or 4 inch difference or not? But it's again, the state of the record here is it's a half an inch undisputed, and that's where we're.
So for us to be able to decide this as a matter of law, would we have to conclude that no rational juror could find this to be negligence? Is that the standard? No rational juror using common sense could find this to be negligent?
Right. Well, right.
Is that the standard we apply? So if we conclude that a rational juror could find this was negligent, then this goes to trial, right?
I think it goes more to an issue of law, Judge. I think it goes to the duty of care. So that would be an issue for the weight of the evidence. But if there's no legal duty, then that issue is not.
But how do we decide that? I mean, that's a mixed question of fact and law, right? So how do we decide that as a matter of law?
Well, I think you decide as a matter of law that the half-inch elevation is not an actionable defect, and no rational
juror could find that was negligent on part of your client. Okay.
Yes. And that is. Oh, thank you. My time is up, Your Honor. Thank you.
Thank you very much. I think we understand your arguments. Very interesting case. The matter is submitted. Our second matter this morning is 2022 P227, Sean Shea versus the Massachusetts Department of Correction and others. This case is partially impounded. Counsel, I'm not sure what's impounded, but I take it that you will make sure to speak generically on that, whatever that subject is.
Absolutely, Your Honor.
Whenever you're ready.
Good morning, Your Honors. May it please the Court, Matthew Coase here on behalf of Mr. Sean Shea. The Department of Corrections has regulations in place that regulate the disciplinary proceedings. The basic premise is that the proponent of the disciplinary report needs to prove its case by a preponderance of evidence. And I would suggest that the Department of Correction has failed to meet its burden of proof in this case for two significant reasons. The first reason is because the mere fact that an envelope arrived at MCI Norfolk with Mr. Shea's name written on it is not proof that Mr. Shea had knowledge or control of the contraband that was allegedly inside of that envelope. I would further suggest that the fact that the hearing officer disbelieved Mr. Shea's testimony did not provide substantial evidence to the contrary. The second reason that the Department of Correction failed to meet its burden of proof was actually demonstrating that the paper inside the envelope was in fact contraband. The Department of Correction relied very heavily upon the NARC-2 field test, which has since been proven to be an unreliable method for determining whether or not that particular contraband is on paper.
So I want to just break this down between the envelope and the letter. So, and I also want to make sure factually we understand. He's shown the envelope and given an opportunity to accept it or reject it, right? And then he signs. Just factually, I want to make sure we understand.
Correct, Your Honor. I think there's a little bit of ambiguity in there, but I would point the court's attention to the language on page 61 of the D report. Officer Melanson says that he distributed the legal mail, and then in the factual component of Mr. Shea's testimony, he was basically shown the envelope, asked if this was him. He said, yes, this is me, and then he signed the paperwork. And I think the evidence indicates that at that point, the corrections officer opened up the paperwork. So it's not exactly clear to me that Mr. Shea had an opportunity to do kind of a very thorough examination of the paperwork that was inside. I think, essentially he was shown the envelope and was given the opportunity to accept it or reject it.
Well, the form he signed doesn't actually say anything, right? He's just acknowledging he's receiving it, right?
Exactly, Your Honor.
He's not making any representation that he understands what's in it or anything to that effect, right?
I agree with you, Your Honor, and I think that was a point that was made in the amicus brief. I failed to raise it myself, but there's nothing within that acknowledgement says that I know what the contents of this envelope are.
The hearing officer found that he acknowledged, where is it? That he acknowledged that he had the opportunity to view the mail and then sign. So do you not, are you saying that there's still some ambiguity whether he just looked at the envelope and signed, or did he actually see the paper inside and then signed?
My understanding and my reading of the record is that he only saw the envelope before he signed. And I think it's clear from the record, and I think, again, I'd point the court to the amicus. There's the affidavit of Joel Thompson. And then there's also the Department of Corrections regulations.
So he's going to get up and say that, first of all, just looking at the envelope, that there's some obvious problems here. There's no capitalization on the street name. MA is not capitalized. And the street address for your client also is not capitalized, nor is the Norfolk or Massachusetts. So what do you say to that?
Well, I say
Is that a
that's
commentary on lawyering in Massachusetts?
Yeah, I would say that the content of the envelope is correct with respect to Mr. Shea. His name is spelled correctly. That is the correct inmate number. The address is correct, and that's why the mail found its way to MCI Norfolk. So we're talking about punctuation and capitalization here. And I would also suggest that, Mr. Shea is an inmate. He, a juvenile serving a life sentence, and certainly probably doesn't have the familiarity with formatting legal correspondence that individuals in our position might have. Another interesting thing about the envelope I wanted to point out too is it appears that there's a stamp on the envelope that says attorney-client privilege. To my eye, I can't tell, obviously this is a photocopy, but it appears that that's a stamp and not just printed on the envelope. And I think that that also gives some sort of credibility that, the person who mailed this envelope had a stamp that said attorney-client correspondence. So I think taken on the whole, and the fact that it was inside a priority mail envelope as well, might have distorted the view that Mr. Shea had. Again, he didn't have an opportunity to thoroughly view the envelope and its contents before it was opened, but rather, just had an opportunity to glance at it, saw his name, and said, yeah, that's me. And I did point to a couple of cases, Your Honors. I pointed to an unpublished decision, which I think is very similar, the Alves decision, which relates to a money order But it was essentially the bottom line was that the court felt as though the mere receipt of this item in the mail really wasn't sufficient to meet the burden of proof that he intended to receive it. I also cite to the Jordan case, which is a case that involves a piece of metal like a weapon that had been deposited into an inmate's cell. And again, obviously the factual circumstances of Jordan are a little bit different, but the basic premise is the same. The mere fact that an inmate receives something is not proof that they intended to receive contraband by receiving that particular item.
Well, so one question I have here, we can't tell from photocopies if you look at the original paper, because this is now, the envelope then is opened in front of him, right?
Yes.
Yeah, and, you know, the department is saying that it's clear the paper was wetted and then dried. We can't tell that here, do you know?
I mean, we can only go by what the corrections officer said, and, you know, I think that the corrections officer's statement under the regulations and under the law can be admitted into evidence. And I don't know for certain whether or not the disciplinary officer had the actual paper in front of her. But that kind of leads to my second argument with respect to the testing in this case. You know, this whole case, the linchpin of this case, relies upon the Department of Corrections' use of this NARC-2 field test. There's some kind of anecdotal evidence made on the part of the corrections officer. But I would point out that,
So obviously I'll ask this of your opposing counsel, but I didn't see that their brief addressed your NARC-2 argument. Did you?
I don't recall seeing that in the brief. I believe that maybe there's a footnote that kind of addresses the argument.
What's the status of the litigation in Green? That was the decision that you attached to your brief is a preliminary injunction, right? It's a decision issued on a preliminary injunction. So
yes, Your Honor.
Has the litigation been concluded? Has the new regulation mooted the litigation?
To be honest, Your Honor, I'm not sure the status on the final stage of the litigation. If it pleases the court, I'm happy to provide you know, that information in a 16L letter.
So how does the new regulation factor into our analysis here when it was not in place at the time of this disciplinary hearing?
Well, I would argue that the new regulation or the standard operating procedure should apply to Mr. SHEA's case because of the due process implications. I would point the court's attention to the Sex Offender Registry Board cases, and where there has been changes with respect to the way that hearings have been done or the way that the regulations have been applied to sex offenders, that has gone back on appeal, and the courts have applied that. They've basically sent it back to the agency or back to the board and said, you know, the courts have said, hey, you know, take another look at this case in light of the changes that have come down. So I would recognize that in this case it was prior to the Green litigation and Judge Davis's findings with respect to the reliability of the NARC-2 test.
But would you have had to go in the Green litigation and ask for such an order to apply to your client, or ask for a modification to the preliminary injunction to cover cases in the pipeline?
I don't believe we would, Your Honor. I think the Green litigation was specific to that particular case. This is
Let me put it to you a different way. Do you think that they are violating the injunction in the Green case by proceeding with this appeal?
No, I don't think that they would be violating, because at the time it was not in place. But my argument is that it should be applied retroactively in the way that this court and the SJC has done in other cases. And as I mentioned before, I think the Sex Offender Registry Board cases provide a very good example of that.
Well, Mr. SHEA didn't challenge the drugs at the hearing, right? In fact, didn't he, it wasn't his defense that he was an unsuspecting mule? So he was acknowledging that, yeah, this was contraband.
Well, I think Mr. SHEA was only in a position to accept it as contraband based upon the evidence that the Department of Correction put into evidence. So the Department of Correction, their whole case relied upon this being contraband through the NART-2 test. But Mr. SHEA didn't have an opportunity to test it on his own. Well, I take that back. He did have an opportunity to test it on its own. He declined that opportunity. And that's where I get to the third part of my argument.
But before you get there, though, I just want to be clear. So the argument you're advancing for Mr. SHEA now is not at all the argument he was advancing at the administrative hearing. The administrative hearing argument was, well, if it's drugs, I was an unsuspecting mule. That his focus wasn't on the drugs. His focus was on his lack of knowledge at the time that it was contraband, right?
Oh, I agree with you that that was his argument at the time, and I don't think, as I mentioned before, he did not have readily accessible testing available to him without payment and a passage of time. But at the same time, that is the Department of Corrections' burden of proof. And Mr. SHEA went to the disciplinary hearing with the intention of holding the Department of Correction to its burden of proof. The Department of Correction has conceded in the Green litigation that this is a highly unreliable method for testing legal mail. And as a matter of fact, I think, as you can see from both the amicus brief and from the Department of Corrections' new standard operating procedure, they don't have a whole lot of faith in this testing method. And now, if someone like Mr. SHEA were to receive an envelope, not only would the NART-2 test be done, but the confirmatory test would be done, and there needs to be some additional evidence that this particular prisoner was involved in trying to bring the contraband into the...
In the SORB context, I thought that the reason rules apply retroactively is because there's a liberty interest that's implicated by the registration requirement. It's the same thing in the criminal context, right? So here you don't have a liberty interest, so why would the new rule apply retroactively?
Well, I would suggest that the gravity of this particular offense, and I would say that there is arguably a liberty interest involved.
What's that, the parole issue?
Pardon?
What's liberty interest?
Well, I think the parole issue arguably could be, but I would also suggest that this particular offense could be referred to a district attorney and he could be prosecuted if found guilty on the disciplinary report. I think when you look at some of the disciplinary reports, it says whether or not it's been referred to an attorney. So if he was in possession of an illegal substance, then potentially liberty issues could be at play if he were to be prosecuted.
Does he have a liberty interest in not being drug tested? In the imposition here, the penalty was drug testing for 2 years. Does he have a liberty interest in being free from that?
I would suggest that any sort of violation of one's body would certainly violate, any sort of liberty interests.
Any other questions? Okay, thank you very much.
Thank you.
We'll now hear from the Department of Corrections, Attorney Tarr.
Good morning, Justices. Ultimately, this decision was based on hearing Officer Vininsky's decision based on viewing of the evidence and the department's observation of the evidence viewed as a whole, not taken as one individual piece of evidence looked at by itself in a vacuum. This case is not a case of mere acceptance. This case is one of a thorough investigation done by the department of mail that was presented to Mr. SHEA with observable numerous errors on the outside of the mail prior to it being opened. Subsequent investigation after the mail was...
There's some lack of capitalization, and he's a juvenile.
He is not a juvenile.
Well, he was a juvenile, and he's been incarcerated. We get cover letters every year from lawyers who don't know how to address a letter, like from law students who don't know how to address an envelope. So when you look, how is this person who has been incarcerated for a crime committed as a juvenile supposed to say, CPCS has attorneys contact us that we don't know who they are, so I'm going to refuse this letter?
Well, Mr. SHEA has indicated in his testimony at the disciplinary hearing that he does receive mail from numerous outside attorneys. So he's able to have seen mail from different perspectives with different punctuation. To say that he's unfamiliar with legal mail would be a misnomer, since he has filed his appeals and has received numerous mailings before. Additionally, he by his own testimony and statements, indicates that he has no connection to Eastern Massachusetts.
How is that relevant to his knowledge that it contains contraband? What's the link there? I don't see it.
It's relevant in that it is one link in the chain as part of the investigation. Mr. SHEA has the opportunity to decline the mail where he is able to noticeably observe errors.
Okay, so maybe he should have known it wasn't legitimate legal mail. We'll just accept that, okay? I don't know, it seems perfectly normal to still sign for the mail, especially when you're in prison, to see what it is.
Not when he's saying that he has knowledge that there's other people trying to smuggle in drugs to the prison, and he claims to be a mule. Why would he sign for mail that he doesn't know, from an unsuspecting source that he has zero connection to, that he has never had any affiliation with, that he himself specifically distances himself only after the mail is opened and found to be suspicious? Otherwise, he wanted the mail because he wanted to get that into the facility.
Okay, but how does that prove that he wanted to get contraband into the facility?
So his signed acceptance of the mail, which is to take ownership and possession and control of the mail, it is not just an acknowledgement that the mail is addressed to him.
But now where does it say that in the record? Because as I saw that receipt, I looked at that receipt, and all it is a signature and a printed name, just acknowledging that you've received it. There's no acknowledgement there that you're acknowledging the contents or you're accepting the contents as true or as yours.
Well, that's why the new standard operating procedure specifically is addressing that, indicating
okay,
that
that's
the
great
signed
going
acceptance
forward,
is
but
not that.
how about in this case? Where is the evidence of that?
Where's the evidence
That he's acknowledging that what's in there is his.
He's acknowledging that he is agreeing to take possession and control of it into the facility. So he is agreeing to attempt to take ownership and control of the original document that's being sent from the outside.
So looking at that envelope that we see in the
Yes.
record, what about that says this is drugs?
Well, Your Honor, I would say that the numerous spelling errors, grammatical errors, and other issues is a red flag to him that it is drugs, and that's why he is signing for the mail. That would be, now that's partially my opinion as far as what the outside of the mail shows, but in conjunction, what the hearing officer was listening to is he signed to accept for it and then backtracks afterwards. So Mr. SHEA's testimony is what incriminated him in conjunction with everything else, as far as not being credible in arguing that I wanted the mail, but oh wait, I don't have any connection to the mail. That portion of it is saying that I'm trying to get it in, but if I'm getting caught, I don't want to be affiliated with this in any way, shape, or form. All of a sudden, now I'm a mule.
Do you agree that under the new guideline, he couldn't be found guilty on this record?
No, Your Honor, I think that he could still be found guilty.
How could he be found guilty?
So he signs for the mail. In addition to signing for the mail, there's other evidence that's being presented to the hearing officer regarding the substantial evidence of his connection. The underlying mail has a cover letter addressed to him. It also contains 5 tainted pieces of paper that were each individually tested. Now, under the new standard operating procedure, each of those pieces of paper would be sent out for
Right, so at least on that basis, he could not be found guilty, right?
I believe that the mail could potentially be resent out to a confirmatory lab test, and we're still at the same point that we are, still at the same position.
But that hasn't been done. I mean, is the mail, is it preserved? Do we still have it?
The mail is still in evidence at MCI Norfolk, to the best of my knowledge. I had confirmed prior to this hearing that it is, to my knowledge, it is still in possession of the department. However, I don't know that that is definitive one way or the other.
You're saying that this new guideline that says an inmate's decision to accept privileged mail standing alone shall not constitute sufficient evidence that the inmate attempted to introduce contraband. You're saying that that guideline does not apply here? Or it would not preclude a finding of guilty here?
No, I don't believe that that would preclude a finding of guilt in this instance.
Why not?
Well, in addition to signing for the mail, there was also a cover letter specifically addressed to Mr. SHEA contained within the mail, as well as 5 pieces of completely unrelated that Mr. SHEA admits are that within his testimony and argument admits to be contraband, which the only reason it wasn't sent out for confirmatory testing was Mr. SHEA declining to have it being sent.
I don't think he admitted. I think he was just assuming it was because he has no basis to prove otherwise unless he gets the confirmatory testing. But the DOC has the initial burden to show by a preponderance that it's contraband, which apparently now the DOC has conceded that the field test isn't enough.
And the field test by itself isn't enough. However, in this instance, that's not the only evidence that's presented to the hearing officer. The attorney that was on the return label from the mailing was contacted and indicated they were not the sender of the mail. The attorney, as well as there was 2 attorneys that were listed on the letterhead and two attorneys for the return address for the second envelope that was within the mailing, were contacted. One is retired in Florida. The other one has 0 contact with Mr. SHEA and has never represented him. The fact that the mail is coming from an attorney that is not his own and did not send the mail, in and of itself, removes us from any of the green analysis by itself. That was done prior to him being, so the Green case, as argued, indicates that the department is not able to issue discipline as a result of the NARC test by itself in a vacuum. However, the Green case is not applicable to Mr. SHEA, and he is not part of the current settlement negotiations for that case at this time because the attorney was contacted, refused to send the mail. Additionally, once the mail...
It's 2 separate issues, right? First, the department has to prove that he knew and intended to smuggle contraband into the prison. That's one issue. And then the second issue is, was it contraband? And that's the Green issue. And Green says that the field test isn't enough. So what's the evidence in this record that the mail, in fact, contained contraband other than the field test?
It did not come from his attorney,
That's
so
not
therefore
proof
it's coming
that
from a fraudulent source.
That's not proof of what was on the piece of paper.
The
right?
only proof that would need to be a preponderance of the evidence that it was an illicit substance.
Right, so what's the
hearing
proof of
officer's
that?
observations of the actual document, the paper, being wet and dried,
That's enough to prove by a preponderance that it contains contraband, that it was wet and then dried?
in conjunction with the attorney refusing or indicating that it did not come from them, yes, I believe that is enough to indicate that it is.
Well, but where's the knowledge that he knew the attorney wasn't the attorney?
He indicated that he had no
I don't
connection.
understand. DOC can say that you have to register as an attorney to send mail, privileged mail to our clients, and then you could just look at the envelope and never show it to the guy. Why does he even need to be involved if we know CPCS assigns attorneys and has them write to inmates, and you know that?
Well, under the new, are we talking about the new standard operating procedure or the one that was in place at the time?
Either one.
So the one that was in place at the time would allow him to refuse the mailing. At that point, there would be no further contact with the original mail, there's no argument that this was official legal mail being sent to him. And it's not affiliated with him, it has no connection to him, and it's not a case about him. It's a printout from an online source. However, so even still, that connection to him doesn't exist. So there's no connection to him and the mailing itself.
The new guideline says that no inmate can be sanctioned or issued a disciplinary report until an outside test confirms that the mail contains contraband. I mean, that's what it says. So
Right.
let's say we were to conclude that the new guideline should apply retroactively. What then?
So if they were to apply retroactively, or at least be used in a new hearing, if that was Your Honor's decision to issue it that way, then under those circumstances, based on the evidence of the attorney refusing or indicating that it was not sent from him, the testimony presented by Mr. SHEA of his, he never said that he didn't want the mail. He always
But
said
it
that
says,
he had
I
no
mean, it
connection to
says,
the mail.
it says very clearly, no inmate may be sanctioned until a test from an outside laboratory is conducted and returns a positive result.
And
So I don't see
if
how
that
you
were to
get
happen-
around that. If this is retroactive, we don't have an outside test. And it says you need the outside test regardless of what other evidence there might be.
And I would be confident that this would be sent out for outside laboratory testing, which Mr. SHEA had the opportunity to do and refused.
So to be clear, I mean, we
Yes.
get unsolicited mail here every single day. It goes into our inbox, and then some of us cannot throw away an unopened envelope. Just can't do it. And so you would say, if there was contraband in there, that we took possession of the contraband, if I understand your argument correctly.
I think that is, I don't think that is the same situation, Your Honor. Because in this case, he is observing the mail prior to it being delivered to him. He is then signing to accept it with the intention of taking possession and control. Mail that's sent to the courthouse is put on your desk and left for
Right, but then
whenever
we
you're able
pick
to
it
get
up
to
and
it.
open it.
After you open it, if it was something, there isn't a security interest that you have in opening the mail here. The security interest at the facility, which was partially addressed in the amicus brief filed by CPCS, related, or I forget it,
Yeah.
was related to the seriousness of the introduction of drugs into the facility. The department's desire to stem the drugs being entered into the facility is a significant issue regarding health and safety of the officers as well as other inmates.
So there's one thing that puzzled me, because we get many cases involving prisoner mail. So we know now that the non-privileged mail, you just photocopy and they get a photocopy, and you've sort of ended that pipeline.
Yes.
Right. And I would have thought, okay, well, you can't do that with privileged mail because you shouldn't be opening the privileged mail, except you do open the privileged mail in the presence of the inmate. So I don't quite understand why you can't just open it in their presence, photocopy it, and give it to them, because you're opening it.
So the issue is that I know the desire for the inmates from the different bars to have the inmates get the original copy of legal mail is still being made, as well as some issues regarding the underlying photocopying of privileged mail, because the level of distrust between the department and the defense bar. So we are making an effort, and there is now, based on the new standard operating procedure, a doubled effort to make sure that there's now two corrections officers that would be required to confirm that the substance is suspicious before it's even sent out for confirmatory or outside laboratory testing at this point. I'm seeing.
All right, well, I do want to make sure we understand the factual part of
Yes.
this. So he's shown the envelope, and then he signs that he wants the envelope.
Yes.
And then after he does that, in his presence, someone opens the letter, the envelope, and they see the pieces of paper that look like they've been wet and dried, and at that point, they don't give him the paper.
No, because it would be a
So I'm
security
correct.
issue. Then it would be taken back to the IPS office, and at the time it was field tested for NARC. Currently, it's not field tested. We do no longer use the NARC 223 test that was the subject of the Green litigation. That is no longer used by the department. Now the suspected mail is sent out automatically for testing at an outside laboratory.
The Green litigation, you said, is in settlement discussions?
Yes.
Let me just ask you a quick question. So if we change the facts a little bit, and what's received in the envelope, the inmate opens up the envelope and he sees, aha, there's a couple of joints in here, and then he just, signs a paper, oh, I'll take this. Clearly, it's contraband. He's thinks he's getting a gift from somebody, right?
Yes.
Okay. But here he opens up the envelope. There's nothing of an incriminating character to the paper. Now, DOC, with knowledge and experience and training and so forth, sees red flags, the misspellings, where it's coming from, the wet and dried paper. But for your average person who looks at this, it's innocuous. It's just paperwork. So how is that knowledge of contraband? Because my concern is DOC is attributing its own knowledge to the inmate.
I don't think you're giving enough credit to the inmate, Your Honor. To say that once the mail was delivered that he wouldn't know then that it's contraband?
But there's nothing in the testimony that supports what you're saying.
There's no specific testimony from Mr. Shea saying that I know it's contraband. I knew it was contraband prior to it being opened. Now, after it was opened, he agrees that it is not legal mail, it is not a privileged correspondence, and there are numerous red flags that he's able to observe as part of the hearing. He even says, if it were me, I would have done it better.
Well, I think anybody looking at that envelope would say, if it were me, I had done it better. But you said that the department is no longer using NARC-2. Why are you no longer using the NARC-2 tests?
As part of the, as a result of the preliminary injunction that was issued in the Green case, the department made the decision following the injunction, which did not prohibit the use of the NARC 223 test, because of the limited nature that the test would be able to provide and information, the department decided that it would no longer be effective to use, and instead decided to have all potential K2 sent out for outside laboratory testing instead of using a NARC test, just based on, so the officers would determine its level of suspiciousness irrespective of an on-site field test at the time. So we are currently not using a field test regarding the K2 on-site.
And so in your brief, do you respond to his NARC-2 argument?
I don't believe I specifically responded. I indicated that Mr. Shea had conceded the point that it was not a legitimate legal mailing, that there was numerous errors and observable issues, that it was not mail intended, or it was not mail that would have a privileged nature. In addition, the hearing officer, in her substantial evidence, indicated that the photos of the underlying test, or photos of the NARC test in addition to photos of the underlying mail itself, in conjunction, were what she based her decision on. So by a preponderance of the evidence, with the attorney indicating that it was not sent from him, the mail being addressed to Mr. Shea, the cover letter to Mr. Shea, the noticeable errors, in conjunction, made the decision that, by a preponderance of the evidence, that it was not, that it was a illicit substance being attempted to be sent into the facility.
Thank you very much. We'll leave it there.
Thank you.
Very interesting. The case is submitted. We're on to our third and final case for this morning's sitting. That's 2022-P-308, Bradley Birkenfeld versus Pamela Birkenfeld. So my notes say we're having a Molly Quinn arguing for Mr. Birkenfeld.
Your Honor, I believe that was a mistake. My name is Mark Swerbalis. I'll be arguing for Mr. Birkenfeld.
Thank you.
And with that, I will begin. May it please the court, Mark Swerbalis here for Bradley Birkenfeld. We are appealing the Rule 12 dismissal of 3 claims in this action for fraud, unjust enrichment, and tortious interference with expectancy. The trial court dismissed the claims for fraud and unjust enrichment on statute of limitations grounds. In doing so, the trial court applied what we say is the wrong discovery rule in making a disputed factual finding of when Mr. Birkenfeld should have known of these claims rather than when he gained actual knowledge of the claims. Actual knowledge is required because of the defendant's alleged fraudulent concealment.
So I didn't quite understand specifically what the fraudulent concealment was.
According to the allegations in the complaint, so the background here is we have a complaint and then a first amended complaint. The fraud and unjust enrichment were in the original complaint and dismissed. The allegations in the complaint of fraudulent concealment were that Pamela Birkenfeld, the defendant, continued to lead Bradley Birkenfeld, her stepson, to believe that she and Bradley's father, Dr. Birkenfeld, were struggling financially, which is the reason why Pamela asked for the additional money from Bradley so that they could pay off their mortgage in 2012. When Bradley would try to talk to Pamela about the need for the money, she continued to act as if they were struggling financially when it turns out, in fact, they were not. She would yell at Bradley not to mention that in front of his father because he would be embarrassed by it. Essentially, she continued with the ruse that she and Dr. Birkenfeld were struggling financially, which was the reason for the request when, in fact, they were not.
So somehow she did end up paying off the mortgage far prior to this suit being filed, correct?
Yes, in 2018, Your Honor.
And so the injury is what?
The injury is that she fraudulently, so through her fraudulent misrepresentation, she solicited the $500,000 conditional gift from Bradley. When she received that money, rather than use it to pay off the mortgage, she diverted the funds elsewhere. According to the allegations in the complaint, for example, she diverted the funds to her stepsons from a prior relationship in Texas. What we learned through the discovery after the original complaints were dismissed is that she deposited some of the funds, it appears, into her own account, in addition to transferring some of the funds as gifts to her stepsons from the prior relationship. And this is part of sort of the unusual posture of this case, where we had the 2 counts of the original complaint dismissed, but in dismissing those counts, the 3rd count for tortious interference with expectancy was allowed to survive, and the court said that discovery shall proceed. And so discovery did proceed, and the amended complaint was filed. After the amended complaint was filed, the defendant filed a motion to dismiss that amended complaint. But so by the time we were at the hearing on the 2nd motion to dismiss, which was in early 2022, we had already had 6 months of discovery. So by that time, the record, as reflected in the first amended complaint, was not representative of what the actual factual record of the case was based on the 6 months of discovery.
But you didn't move to amend the complaint, so we're left with the complaint as it is.
Excuse me, Your Honor?
You didn't move to amend the complaint after you got the discovery.
No, Your Honor.
So we're reviewing the complaint as filed.
You are reviewing the amended complaint as filed, or the first?
The first complaint on the statute of limitations issue.
Well, we did not move to amend the complaint.
So on the statute of limitations, she did pay off the mortgage eventually. So your claim is that the fraud is that she didn't pay it off soon enough? Is that the claim?
The fraud, so the way that the conditional gift came about is that our client Bradley was going to give his father and Pamela $350,000. She asked for $500,000, so an additional
I understand the facts, but what is the claim of fraud, that she didn't pay off the mortgage soon enough?
Yes,
So how could she possibly conceal that fact?
well, she did conceal that
How
fact.
could, I mean, she couldn't conceal the fact she didn't pay off the mortgage even if she wanted to, because you could go look it up and see that it hasn't been paid off. So let's say the claim is that, or your client believes that she promised to pay off the mortgage within 1 year. What prevented him from, in a year, going and seeing if the mortgage had been paid off?
Nothing prevented him from checking the online registry of deeds, and so that was the basis for the trial court's decision that
Why is that wrong?
because he had no duty of inquiry under the circumstances, Your Honor. So the trial court relied on an SJC decision from 1976 called Friedman versus Jablonski. And in that case, the statute of limitations accrued, the claim accrued based on what was in the online, or based on what was in the records at the Registry of Deeds. That was prior to the online records. In that case, had to do with a misrepresentation as to the existence of a right-of-way. But the court, the SJC, and I'm quoting, Your Honor, stated that we stress we are not saying that an action for deceit does not lie because the plaintiffs should have inquired at the Registry of Deeds. An action for deceit is not barred as a matter of law because the victim...
It's not barred as a matter of law, but as a matter of fact. If your claim is that she should have paid off the mortgage within a certain period of time, then I don't get it. So your client could have waited 20 years and then brought the claim? He had no duty to go look up to see if she had paid off the mortgage?
So we say he had no duty, Your Honor.
So 20 years later, he could have brought the same claim?
He could have if he didn't discover it until 20 years later. Where there's fraudulent concealment, the actual knowledge standard applies. Another case that's instructive here, Your Honor, is a case from May 3rd, 2022, an unreported decision by the appeals court called Glazer versus MTGLQ Investors. We cited in our papers. And the court there held that until some issue was raised with respect to the recorded mortgage because of the fraudulent act in the filing of a false acknowledgement on the mortgage, the plaintiff would have had no reason to be aware of a completely false acknowledgement had been recorded. Here, it's similar. Bradley Birkenfeld had no reason to be suspicious.
But in that case, there is an affirmative act of fraudulent concealment. It's a filing of a false acknowledgement. You don't have that here.
The fraudulent concealment is the continuing misrepresentation that Pamela made to Bradley.
I don't see in your opposition below where this statutory discovery rule was raised.
Excuse me, Your Honor?
So your opponent argues that this issue is waived, the statutory discovery rule. And I looked in your opposition, and I don't see the statute cited. I don't see the statutory rule discussed. I just want to give you a chance to respond to that.
You do not see the statute cited. You're correct, Your Honor. What you will see, or what you have seen, is our citation to the rule as articulated in Patsos versus First Albany Corp. This is the same case that Pamela Birkenfeld first cited, relied upon, and argued in her motion to dismiss. We responded to that argument in our response to the motion to dismiss, again citing the Patsos decision, which we believe is the seminal decision.
Did you ever argue that the standard is actual knowledge?
I'm trying to think back to our brief.
The way I read the opposition is that your client had no reason to discover, he couldn't have reasonably discovered. That's the common law rule. That's not the statutory rule.
But we cited that, we alleged that there was fraudulent concealment, Your Honor.
But did you ever argue that the standard was actual knowledge?
I don't know, Your Honor.
Let me ask you a question. You referred to the gift as a conditional gift. What do you mean? What are the conditions of the gift?
That the additional $150,000 on top of the $350,000 that was originally going to be given was for the purpose of paying off the mortgage right away, because according to Pamela Birkenfeld, she and Dr. Birkenfeld were struggling financially and needed the money to pay off the mortgage right away. I'll turn to the claim for tortious interference with expectancy because I think this is a significant issue. Here, we met the standard for alleging a claim for tortious interference with expectancy. We satisfied the elements in the complaint and in the amended complaint, and then through the discovery that was taken in the 6 months following the dismissal, the first motion to dismiss decision,
So am I understanding the trust document to say that in the end, she gets to decide what happens to both trusts, but she gets to choose among the 3 brothers, or she can do all of them, but she can exclude your client?
She can, Your Honor. And so this was
So
actually...
then how can he have an expectancy?
Because, so this is where we say the trial court misconstrued the terms of the trust. And so what the trial court ruled on page 308 of the record appendix is that it is only after Pamela's death that the plaintiff could receive a portion of the principal of Trust A and the principal and undistributed income of Trust B, and only if Pamela directs such a distribution to the plaintiff in her will. That's actually backwards. So Bradley Birkenfeld and his 2 brothers are remainder beneficiaries of the trust until, for as long as Pamela is alive, right? So she is the primary beneficiary during her life. She receives the income, and in the trustee's discretion, she may receive distributions of principal. Whatever is left at her death goes to the remainder beneficiaries. But she has a power of appointment that she can exercise in her will, a testamentary power of appointment. And with that power of appointment, she can direct who among the 3 brothers gets what. And so in theory, she could exercise her testamentary limited power of appointment to say that Bradley Birkenfeld gets nothing through the trust. But because it's a testamentary power of appointment, it cannot take effect. It cannot be exercised as a matter of law until Pamela's death. And even if it's exercised, the exercise has to be valid. It has to be done in a certain way that meets certain technical requirements. It has to be done in her last will and testament that needs to be a valid last will and testament. Unless and until that happens, Bradley remains a beneficiary of the trust. He is a remainder beneficiary of the trust. So that was one error that the judge made. She misconstrued the terms of the trust. The second error is a related error. So what she held, in effect, is that in interpreting a claim for tortious interference with expectancy, that Bradley doesn't have a legally protected interest because he doesn't actually receive money upon his father's death. In other words, he wouldn't receive anything, if at all, until after Pamela's death. This adds a limitation to the claim for tortious interference with expectancy that's never been recognized before. And so what does this mean? Why is this important? It's important because under the most basic form of estate plan, which is what we have here, which provides for the surviving spouse after the decedent's death and then the children after the surviving spouse's death, that the children, if this limitation of the claim were applied, the children would be barred from asserting a claim for interference with expectancy. It would effectively eliminate the rights of all remainder beneficiaries under the trust, under any trust, which has never before been recognized in Massachusetts or, as far as we know, in any other jurisdiction. That would include, Your Honors, significantly charitable remainder beneficiaries. So this would have a wide impact on the import of when and how a claim for interference with expectancy can be asserted.
So would we have to rule for you on both issues to rule for you, to reverse?
On the interference with expectancy claim?
Yes, yes. You're claiming two different errors.
Actually three errors, Your Honor. The third error is that the amended complaint didn't reflect the facts as they had been developed in the record, and those facts were brought to the judge's attention during the hearing. Any one of those errors would be sufficient to reverse, Your Honor. What we're asking for is reverse the dismissals of the three claims, remand them to the probate or to the Superior Court with leave to amend so that the new pleading can reflect the facts as we know them now.
So I think that may be where you started at the beginning with Judge Shin. So you're saying that our analysis is not limited to reading the first amended complaint, that we also should be looking at any facts that were raised to the judge at the hearing.
Yes, Your Honor. And in fact, you can take judicial notice of the affidavit of objections that was filed in the related matter in the Norfolk Probate and Family Court. That's attached as an addendum to our reply brief.
Does that probate matter have any role here?
It does not have, well, I mean, it has a role in the sense that the facts that were discovered in the limited discovery are laid out in the affidavit of objections in the probate court matter. It is a related but separate case. It also will be finding its way up to this court for an appeal on a standing issue.
Just have one last question.
Sure.
So the plaintiff has substantial means, is laid out here.
He does, Your Honor.
North of $100 million. So to the average person, paying off a $500,000 mortgage would seem quite generous and a substantial amount of money, but it's kind of a drop in the bucket. Doesn't that, as far as the plaintiff goes, so doesn't that kind of enter into the calculus as far as the whole question of fraud? I mean,
No, Your Honor.
In other words, it seems like a very small sum of money, and circumstances can change, that maybe the need to pay it off right away dissipated, and we're able to, stay above water for a little bit of period of time, and then, in other words, it doesn't, the essence of fraud seems to be missing from all of it in the big picture.
Because of Bradley Birkenfeld's wealth?
That's part of it, yeah.
So I'm not sure I understand the question, and so I apologize for that. But what I would say is that fraud is fraud, regardless of the means of either party. If there was a misrepresentation made with intent to deceive, and if the other party relied on that misrepresentation to his or her detriment, then that is actionable fraudulent misrepresentation. And here, why I keep coming back to what the additional discovery produced in terms of evidence of additional wrongdoing is that this isn't just about the money. Because you're right, Bradley Birkenfeld is wealthy. But it's about what he perceives as his stepmother's treatment, and I'm hesitant to say the word abuse, her mistreatment of her father, which did not come to light for Bradley until 2018 or 2019, when he gained knowledge of the misrepresentation regarding the mortgage, and which caused him to dig deeper. From his perspective, it's a troubling situation in lots of different ways, not just confined to that payout.
Okay,
Thank you very much.
we'll hear from Attorney Ford.
Morning, Your Honors. May it please the Court, my name is Scott Ford, and I represent appellee Pamela Birkenfeld. The decisions of the Superior Court below should be affirmed because, as a matter of law, they are correct, and Bradley Birkenfeld's case is fatally and fundamentally infirm. By way of just brief additional background, I know the court's aware of this, but Pamela Birkenfeld is the elderly widow of Ronald Birkenfeld. Ronald Birkenfeld has 3 grown sons from a prior marriage, one of whom is Bradley Birkenfeld, the plaintiff here. Bradley Birkenfeld is wealthy and lives in Malta. Ronald Birkenfeld died on December 25th, 2020. The very next business day, Bradley Birkenfeld filed this case against his stepmother, asserting claims for fraud, unjust enrichment, and tortious interference with expectancy. The tortious interference and fraud claims were dismissed by the Superior Court Judge Frenier in March of 2021, with leave to amend the tortious interference claim. That was accepted and then represented back to the court. That amended complaint was also dismissed by Judge Donatel in May of 2022. And as Attorney Swarbalis indicated, this is the 3rd time that Bradley Birkenfeld has sought relief from this court. The first time was a single justice appeal in response to Judge Frenier's decision that was denied. We were obviously here today, and as Attorney Swarbalis said, there is a probate case, another complaint that Bradley Birkenfeld asserted against Pamela Birkenfeld, containing many of the same factual allegations as we have here, that was dismissed by Judge Moriarty in the fall of 2022.
So your opponent has argued that because this was, one of the claims was fraudulent concealment, that his client needed to have actual knowledge. It's not enough that he could have checked the registry. What do you say to that?
As this court is well aware, the statute of limitations can be told in one of 3 instances, assuming that the statutory rule applies. 1, where the issue is inherently unknowable. Bradley does not and cannot allege that here, because an easy search and free search over the internet in the Norfolk County Registry of Deeds would confirm that, whether that was in 2019 or 2012, whether you're in Malta or in Dedham. Number 2, if there was a breach of a duty to disclose, Bradley does not allege that here. Number 3, if there was fraudulent concealment. And as Justice Shin said, fraudulent concealment requires some active act, some affirmative act of concealment. So if we look at the Maglia Kane case, that was a case where the town of Gardner was accused of having contaminated water. The court there did apply the fraudulent concealment exception and doctrine. Why? Because the town came forward and said, there's nothing wrong with the water. That's fraudulent concealment. Here, there's no allegation that Pamela Birkenfeld said anything to the effect of, hey, Bradley, I paid off the mortgage by the deadline we didn't discuss. No need to go check the Registry of Deeds. And instead, because the argument was never pled in the complaint or the issue raised, because it was never addressed below in briefing, Bradley Birkenfeld attempted to concoct a post hoc claim of fraudulent concealment based upon what? Based upon Pamela Birkenfeld's statement that they were continuing to struggle financially. That is hardly active fraudulent concealment. It's neither active nor concealment. In fact, one might wonder that if they recently gave $500,000 to someone and then they said, we're struggling financially, it might make one wonder what happened to the $500,000 as opposed to concealing whether or not it was used for the mortgage. And so, as a matter of law, the fraudulent concealment argument is waived, but even if it were considered by this court, there's no affirmative fraudulent concealment, Your Honor. With regard to that claim, though, claims, undue, unjust enrichment and fraud, there are at least 2 independent bases for dismissing that claim. The statute of limitations, Judge Frenier took the hard one and went through a lengthy statute of limitations analysis that rests, falls, and ends with the fraudulent concealment argument that Bradley puts forward here. But there's a much simpler way to dismiss those claims. That is under 12b-6 for failure to state a claim, because the facts, as pled, are exceedingly simple. That money was paid, $500,000 was paid for the purpose of paying the mortgage. The mortgage was paid 7 years before its maturity date. That's it. There's no fraud. There's no unjust enrichment. Those claims can easily, much more easily, be dismissed on the basis of failure to state a claim, which this court can do by virtue of the fact that it was briefed below, even though Judge Frenier did not discussing.
So I think he would argue, well, they were supposed to be paid off within a reasonable amount of time after they got the money, and it wasn't paid off for 6 or 7 years. What's your response to that?
Well, Your Honor, several-fold. One, it wasn't alleged, and it's his burden under Albrecht to allege statute of limitations issue. The 12b-6 argument and the statute of limitation arguments are independent bases for dismissal, but they're interrelated. Either on the one hand, there was no conditional time period within which it was to be repaid, and it can be dismissed under 12b-6, and that's the way it was pled. Or two, generously giving all inferences to the plaintiff here, one could say that it was supposed to be paid by some period of time. That should have been alleged. However, what do we know from the facts? The facts, as alleged, was that the $500,000 payment was to be made to pay off the mortgage. And on page 9 of appellant's brief, they specifically say that the money was to be paid to pay off the mortgage in 2012. Judge Frenier was a little bit more generous and gave an additional 2 years in her footnote for when it should have been discovered. But Bradley Birkenfeld did nothing in 2019 by going online than he could have done in 2018, 17, all the way back to 12. And so under either scenario, under either argument, there are other arguments on fraud, 12B, 9B and the like, but those are the two straightforward ways of affirming the dismissal of the fraud and unjust enrichment claims. And so if we turn to the tortious interference claim, as we know from the Labonte decision, tortious interference of expectancy is of limited application, and it only applies where, one, there has been unlawful interference, with two, a legally protected interest, that three, continues up until the point that that interest is realized. Here, the focus is on point 2. What is Bradley Birkenfeld's legally protected interest? He tells us what his legally protected interest is in paragraphs 31 and 32 of the amended complaint, that he is a qualified beneficiary under the 2007 Ronald Birkenfeld Irrevocable Trust. As we went through the scenario with Attorney Swerbalis, Bradley Birkenfeld's contingencies there is quadruple. Number one, Pamela has to die, and that's the most operative fact that we'll turn to in a minute. Number two, Bradley would have to be alive when she died. Number three, she would have had to make provision for Bradley in the trust, which she does not have to do under section 6.2 or 7.2, and instead can give all of it to one or both of the other brothers. One might surmise what's been done with regard to that, but that's irrelevant for today. And four, there have to be assets available because she has full right to both the principal and the income of both shares of that trust during her lifetime. But it is that first point that is determinative and dispositive of the tortious interference claim, because the Colecchia decision told us what is a qualified beneficiary and held that where one does not take until the death of a second to die, in this case Pamela, that person is not a qualified beneficiary for purposes of the tort. And yet in the briefing, Bradley Birkenfeld says, oh, a qualified beneficiary, that's irrelevant, that's a red herring, despite the fact that it was the fundamental underpinning of the claim that was pled once he was already given leave to amend. And instead, what he says to this court is, don't worry about that. Instead, look at the case law that says that a son is the natural bounty of his father's estate, or such non-such like that, which is hardly enough to establish qualified beneficiary. This case, based on the allegations, is on all fours with Colecchia. It disposes of it, and if we need to discuss it, we can, but the alleged interference that was presented orally at the evidence that was presented orally at the trial court level is, even if we take it as true, is irrelevant because he is not a qualified beneficiary under Colecchia.
So opposing counsel says if we go with that argument that we're potentially devastating the charitable remainder interest. What do you say to that?
Not at all, because You have to look as to whether or not who is a qualified beneficiary. Charitable trust can be drafted in many different ways, whether it's a first to die or a second to die. Here, however, it is very clear. This was structured in a way that Bradley, if he were ever to take it all, would only take upon the death not of his father, but of Pamela BIRKENFELD. And Colecchia makes it clear that that claim, if there's ever to be a claim, is not ripe as a qualified beneficiary until the second to die.
So if there was an allegation that Pamela interfered in the execution of the will, would that be enough to state a claim, actionable claim? I'm just trying to distinguish between what was alleged and what seems like.
Well, Justice Shin, it's undisputed that there was no interference with the will.
Right. I'm just trying to understand the nature of the claim here. So he does.
That would be a different claim. That would be an undue influence claim. One that
would that support a tortious interference claim?
I think it would be different. I think it would be undue influence, and if it were tortious interference with the will, it would still pour over into the irrevocable trust that provides for these multiple layers of contingency, including and especially that Bradley would not take until the death of Pamela. That would still fall under the Colecchia decision. So under your scenario, Justice Shin, that could be an undue influence claim, which is expressly denied here.
So let me just make sure I understand this. So there's two trustees, Pamela and an independent trustee, is that correct?
That's right, Justice Hodgens.
And so this goes back to my question about the wealth of the plaintiff. If he's all set, worth $100 million, no need for further money from the trust or any other source, and if both trustees are in agreement with that, and they say, well, that's the end, there's no need for him to get any money, doesn't that address that but-for language in the Kozlowski case, that but for wrongful interference with a devised legacy or gift that would go to the plaintiff, that has to be proven? So in other words...
No, because there is built-in discretion, intended discretion under Section 6.2 and 7.2 of the trust, where Ronald expressly said that Pam has the authority to give to one, two, both, all three of the brothers or two of the brothers, and not Bradley. And I would say, Your Honor, your question cuts to the heart of this matter. There is clearly discord between Bradley and his stepmother, evidenced by the timing of this lawsuit and the perpetuation of this lawsuit coupled with others. And the fact is, she is spending what she was otherwise counting on for her retirement on legal fees on this quest of litigation that should end. And that is the heart of the matter. And that is why the infirmity of this case, both with regard to the unjust enrichment and fraud claims and the tortious interference claims, were proper and correct as a matter of law, and both dismissals should be affirmed.
All right, thank you very much. The matter is submitted. I want to thank our staff and clerks today for their assistance. And again, happy Valentine's Day.